April, archivists, administrative lawyers, and judges had an official meeting. The conference promised pure boredom. Archives, the empire of grey employees with thick glasses, old paper, dust, musty air, gloomy light. But stop. Something has changed, even in Germany.
Akten sind vielfach nur langweilig für den, der zu faul ist, sie zu lesen.
Suddenly, there is a serious battle for the old paper. Who owns it? Who has the authority for interpretation of history? And that means power.
Immer wieder kommt es vor, dass der Anbietungspflicht unterliegende Unterlagen vor der Anbietung vernichtet werden, sei es aus Unkenntnis der Rechtslage, sei es, weil ein verschrobenes und antiquiertes Chor- und Anstaltsdenken sich nicht damit abfinden kann, dass die Unterlagen eben nicht einer Behörde gehören, sondern der Allgemeinheit und damit nachher dem Bundesarchiv angeboten zu werden.
The bureaucratic establishment is locking itself behind privacy regulations. Together with policymakers, they form a front against the citizens who want to write about history. Maybe a history that is not the official one, but one that reflects the real events.
Es gibt in Skandinavien Vorläufer des tatsächlich in Deutschland erst 2006 in Kraft getretenen Informationsfreiheitsgesetz, die 250 Jahre zurückliegen. Auch Amerika mit dem Freedom of Information Act war viel, viel früher dran. Deutschland musste, auch von der Europäischen Union, gedrängt werden, endlich auch in Deutschland Aktenöffentlichkeit durch ein Informationsfreiheitsgesetz einzuführen.
Back in 2001, the European Union implemented a regulation regarding the access to documents, and 5 years later, the government in Berlin finished the IFG, the German Freedom of Information Act, a half-hearted construct because it excludes the intelligence services from any obligation to provide information.
I have been suing government agencies for almost 40 years. On the beginning, it was for privacy protection, then against the large-scale electronic control, then for the files of the German secret services, and now for the records of the foreign services.
We're mainly fighting against the militarization of the internet, and this has always something to do with power and power structures. And to understand those, it's very important to look into history as well.
I have been working as an investigator since 1978 for Stern magazine, the daily newspaper Taz, and above all, the public radio and TV channel ARD. Many of my articles deal with the work of intelligence services and the police. And these institutions have used their official data to denounce me to my employers.
I wanted to visit several prisoners, but the Berlin Senator of Justice refused. He quoted from a secret report of a police informer, and according to that, I had, during the 70s, expressed my doubts about the suicides of some prisoners in the high-security jail in Stuttgart. The Senator of Justice denounced me to the Stern editorial office. A little later, the director of the radio station, SFB, received the hint that I had been sentenced as a juvenile for slandering the Federal Republic of Germany. He ordered his editors not to give me any work. The professional ban lasted months and would not be the last one. I knew Egert Swan, member of the conservative Christian Democratic Party, and law professor. He was outraged and wanted to prove that such methods were intolerable in a democracy. Schwan complained against the Internal Intelligence Agency in order to obtain the release of the files about me. At that time, hardly anyone spoke about privacy and data protection. That changed in 1983 with the censorship verdict of the German Federal Constitutional Court. It affirmed the informational right to self-determination. My proceedings against the agency then went to the Federal Administrative Court, which took 7 years to dismiss my complaint. After my professional ban, Schwan also filed a lawsuit against the Berlin police president and the Federal Criminal Police Office, BKA. In the first instance, the judges took 5 years, and the administrative court needed a further 6 years, with the result that the BKA was forced to pass my personal record over to me. But the BKA had destroyed a lot of the pages. Schwan filed another complaint. It ended with no result. In 1990, he filed a constitutional complaint. This was 10 years after the first negative decision of the intelligence agency. And it took 10 more years before the judges in Karlsruhe decided not to accept my complaint. The legal situation has now changed, they said. No surprise, given that 20 years have passed during this legal action.
Since the mid-80s, I'm reporting from South America, and I did not find it funny at all when, in 1994, the federal government passed the anti-crime law.
It authorized the Foreign Intelligence Agency, similar to the CIA, called the Bundesnachrichtendienst, BND, to oversee large-scale telecommunications abroad. The technology had advanced, and the agency in Pullach did not want to miss the modern possibilities. I complained, as did the Berlin daily newspaper Taz, before the Constitutional Court. The other foreign correspondents considered my fears exaggerated, that the BND could monitor their research and hinder it. Today, after whistleblower Edward Snowden, we know that my fears were understated. I received support from the small civil rights groups and from lawyers who provided legal help pro bono or for a little money. But not from my professional associations, the big media, and nothing from the political parties. In 1999, the anti-crime law was declared unconstitutional, but returned with minor changes. Once again, I appealed in the European Court of Human Rights, in vain. I am researching the topic of Adolf Eichmann, a former SS officer who the Mossad claims to have kidnapped in a heroic action from Argentina. I quickly realized that this version cannot be true. In 2008, I wrote a pleasant letter to BND, asking for their Eichmann files. They felt so untouchable, thanks to the IFG's exception, that they replied, "Yes, we have 4,000 pages, but we do not want to show you a single one." This was a big mistake. I filed a lawsuit against the BND for access to their Eichmann files. My lawyers were relying on the Bundesarchivgesetz, the Federal Archives Act, that says that after 30 years, the records are basically open and must be transferred to the archives in Koblenz. The BND called on the government for help. However, the administrative court declared the classification of the records from the German Chancellor's office illegal. In the end, the BND was allowed to keep only 100 pages about Eichmann's secret. Unfortunately, many pages were completely blacked out or unreadable. In any case, my lawsuit opened a way for all other investigators. After 30 years, the mystery is basically solved. In Argentina, civil society calls for the active review of the dictatorship of the 70s. Torturers sit in prison. The military says that many of their archives have been destroyed, so we have to look elsewhere. For example, their collaborators. In that time, the internal intelligence spied in Germany on Latin American refugees, and the BND maintained a liaison officer at the German embassy in Buenos Aires. The BND gave me some papers, general statements copied from somewhere. I wanted all files, and I went back to the administrative court. In the previous dispute over the Eichmann files, Ms. Merkel's office had named potential diplomatic problems with Israel if the material was completely disclosed. That is why I submitted to the court a letter from the Argentine government saying that they themselves wanted disclosure. Nevertheless, the Chancellor again blocked the release. The welfare of Germany was at stake. Intelligence agencies promised secrecy forever, even to the repressive agents of fascist regimes, 40 years later. Ms. Merkel does not care that she is withholding evidence from the Argentinian law enforcement authorities. The welfare of the BND is more important. The court requested the resident reports. There was no vital information, just trivialities, orientation for management, and studies about political situations, assessments that completely miss the reality. The Foreign Office must have regularly laughed at these fantasies. A few weeks before the coup in Chile, the BND reported about a planned interim government of the Broad Center, with the consent of the military and the Communist Party.
The communists will avoid any risk and enter into a political arrangement that secures their existence.
Referring to the perpetrators of the coup, BND had a positive overall impression. Not a word about the massive torture and murders. They were called draconian measures. BND said that there were no solid figures on the number of deaths, but it was quite certain that the numbers published in the international press are considerably exaggerated.
The arrested politicians are treated relatively well.
The BND had worked closely with the Latin American intelligence services. Particularly faithful was the relation with the Argentines, after the coup in March 1976. The partner services described with details their repression. The BND reports to Polach,
No prisoners were taken.
information about German arrested persons was provided.
The connection was routinely handled through the exchange of information and conversations.
CG20, the code name for the resident BND office in Buenos Aires, meticulously lists the messages of the partner service. Only the Paraguayan despots did not lose time with writing. The BND was helpful.
We could try to incentivize them to greater cooperation by providing them with information about Paraguayan citizens living abroad.
Statistically precise, the BND reported about cocktail parties. They ordered wheat beer from Bavaria in order to fulfill their sovereign duties. CG20 was allowed to purchase an electric typewriter. The request for a personal computer was rejected. Polach was not yet up to date. The purchase of a strong box was approved up to 500 Deutschmarks. Was there a double floor? This was not revealed to the financial department. To be well informed, CG20 begged for a subscription to the news magazine Der Spiegel. After all, one must know what is going on in the world. The application was approved. Also, the request for a new set of tableware went through. How else, if not with knife and fork, could they defend the values of the free world? The coffee machine remains a mystery until this day. Did it have a special filter? The BND did not reveal the information to the Federal Administrative Court and blacked out the note. And then, a scandal. Is world peace in danger? Yes, almost. CG20 informed excitedly to the Home Office that his guest toilet was broken and that he had to call the plumber and had to leash his dog, a German shepherd.
After that, the Panasonic radio disappeared. I thought in October that my wife had simply cleaned up, but it was gone.
How much a resident earns is not evident from the documents. The remuneration is adapted to those of the diplomatic service. Again and again, the man from the BND called for an increase of his financial means. In the 80s, in Latin America, the generals retreated into their barracks. The last one, Augusto Pinochet, gave up in 1989 in Chile. His secret services, however, survived democratization without major changes.
Pinochet wants to avoid under all circumstances that the new government under the Christian Democrat Elwin has access to the country's intelligence service that stands accused by all political parties of human rights violations. Therefore, before inauguration of his successor, Pinochet wants to incorporate the agency into... So he continues to use the staff of the agency, with its experience, equipment, and files, without being obliged to make the information accessible to the new government.
The German Chancellery does not want to reveal the whole information to the Chilean prosecutors. Only the German Foreign Office complained about collaboration of the BND with the Chilean secret agencies.
I had a conversation under four eyes with the ambassador. Once again, his ambivalent attitude to our work in general, and in particular in Chile, became clear. He reiterated his concerns about working too closely with Chilean officials.
But the Chancellor's office approved everything. Stealing records and hiding them is not legal. This is clear to the whole world, but not so in Germany.
Besonders prominent sind die Fälle, wir haben es eben schon angesprochen, in denen politisch Handelnde amtliche Unterlagen mit dem Ausscheiden aus dem Amt als persönliches Eigentum betrachten und widerrechtlich mitnehmen. Zum großen Leidwesen der staatlichen Archive wiegt hier das Gewicht der Parteien in der Rechtswirklichkeit schwerer als die Norm des Bundesarchivgesetzes.
These stolen documents end up, after the respective politician's death, at the libraries of the foundations of the political parties. Although These are financed with public funds. They decide all by themselves to whom they wish to show the files and to whom not.
Kein Parteiarchiv und kein Privatarchiv ist nun mal gezwungen, die Regeln des Bundesarchivgesetzes umzusetzen.
I'm researching the so-called Agreement of Reparation with Israel of 1952 and the payment of 630 million Deutschmark to Israel, which financed the Dimona nuclear power plant.
Hans Globke and Hermann Josef Abs represented the federal government during these negotiations. Globke was the author of the official commentaries on the Nuremberg racial laws, a senior official of Hitler, and then state secretary under German Chancellor Konrad Adenauer. After his death, his daughter handed over his papers to the Adenauer Foundation, which refused to show the papers to me. The estate of Abs, an economic expert and Hitler loyalist, is located in the Historical Institute of the Deutsche Bank. The bank does not want to show it to me. I then asked the Federal Archives to provide me with the files.
Bislang ist es uns von Seiten des Bundesarchivs noch nicht gelungen, eindeutig amtliche Unterlagen aus den in den Archiven der parteinahen Stiftungen verwahrten Nachlässen herauszuverlangen. Das müssten, so haben das die Gerichte entschieden, die Behörden selbst tun, deren Unterlagen entfremdet wurden. Tun sie aber nicht.
Wir haben zuletzt, darauf möchte ich hinweisen, vom Auswärtigen Amt einen Erfolg errungen. Dort haben wir die Herausgabe von Akten, die aus der Zeit vom ehemaligen Außenminister Genscher stammen, verlangt. Und auf unseren Druck wurde am letzten Tag der von uns gesetzten Frist plötzlich eine Ladung mit 26 Kartons an Akten dem Auswärtigen Amt zur Verfügung gestellt, die jetzt, und das ist ein großer Erfolg, der Öffentlichkeit zur Verfügung stehen.
My criminal complaints against Deutsche Bank and the Adenauer Foundation for hiding stolen records were not accepted. In Germany, federal prosecutors are not independent like judges, but are obliged to follow instructions of the Minister of Justice.
Die Verwaltungsgerichte sagen bisher in 3 Instanzen, einschließlich des Bundesverwaltungsgerichts, dass das Informationsfreiheitsgesetz ein Tiger ohne Zähne sei. Denn da steht zwar drin, dass die Akten ins Bundesarchiv gehören. Die Verwaltungsgerichte sagen aber, wenn die entsprechenden Politiker die Akten mit nach Hause nehmen und nicht abliefern beim Bundesarchiv, dann kann man da halt nichts machen.
In July 2017, the Constitutional Court rejected my complaint for formal reasons. But the judges emphasized that the stolen files remain property of the state, and that the bad habit of hiding them in private archives and showing them only to certain investigators violates the so-called principle of equality. In my research, I discovered that in May 1960, the Pentagon tested atomic bombs in Argentina. This was apparently covered up with the Eichmann kidnapping story. His alleged abduction was a series of embarrassments. There is a large divide between what is in the history books and what really happened. There even exists a secret treaty between Argentina and Israel about these events. But how to crack the old bilateral vows of silence? My requests regularly get stuck in the general bureaucracy, or at best on the minister's desk, but they do not advocate an honest administration. Ministers make excuses, look for the back door, play for time. In 2016, my Argentinian lawyer filed a lawsuit. The law governing free access to information was passed later on. We based our case on the Constitution.
Bueno, acabamos de presentar un amparo por mora porque el Ministerio de Relaciones Exteriores y Culto se ha negado a entregar una documentación a través de un tratado que firmó el Estado argentino con el Estado de Israel a raíz de la detención de Eichmann en territorio argentino. Esperamos que con esta medida se le intime al Gobierno Nacional y al Ministerio de Relaciones Exteriores en particular a suministrar los documentos requeridos.
The Administrative Court in Buenos Aires rejected my request. The judge did not discuss the evidence that I had submitted, did not even ask the Foreign Ministry for the treaty. He ruled, without conducting an open court hearing, that the ministry had not violated its duties. In Israel, documents are open after 50 years. Therefore, the Eichmann story should have become public in 2010. To prevent this, the period of classification was extended to 70 years. However, historians can apply for reducing the time limit. The Mossad never answered my requests. That is why my lawyer has now applied for disclosure of the Eichmann file of Mossad. Otherwise, she will file a formal complaint in Israel. Our chances are good. The Mossad used no other case as intensely for publicity as the heroic abduction of Eichmann. For years, this fairy tale was readily available to everyone on its homepage. The Soviet and Russian authorities have never said anything about Eichmann. For a long time, the civil society had to accept the country's lack of transparency. This is now also changing in Russia.
The maximum term for secrecy is 30 years. So if some document were classified, it can be classified no longer than 30 years. After that, this term can be prolonged only by special government body, which is called Interdepartment Commission for Protecting State Secrets. And recently, in 2014, this Interdepartmental Commission created the decision which prolongs the secrecy of many documents which were created by intelligence services.
This lawyer works at Team 29 in St. Petersburg. The group is specialized in freedom of information requests. Russian journalists who are investigating cases of corruption and related political as well as historical issues are increasingly looking for official documents. Team 29 also represents me.
I think that the court is the most effective instance for protecting also the right to access to information.
Article 29 of the Russian Constitution guarantees Russian citizens the right to information. What I want to know from Russian archives refers to the year 1960, that is, events well over 30 years ago.
We have many documents in archives, in Russian archives, from Soviet period, which is still classified. So in the Soviet Union there were tradition of classifying many things, many documents which were created by government. For example, even statistic of death statistic was classified. Our law on state secrets has such possibility for government bodies to make a petition to Interdepartmental Commission for prolonging the period of secrecy of some documents. If these documents were established like secret in previous year, for example, in Soviet Union. It means that many documents from the period since 1970s till 1991, they are now the period of their secrecy is prolonged for 30 years till 2044. I hope and I believe that we will be successful.
The Russian opposition is committed to transparency. This is not the case in Germany. All the political parties slow down the process. Indeed, they are the ones making the laws. The citizens are at their mercy. The Federal Archives, too.
Leider hat der Gesetzgeber es verabsäumt, wie vom Bundesarchiv durchaus vorgeschlagen, hier entsprechende Klarheit im neuen Bundesarchivgesetz zu schaffen und einen Herausgabeanspruch des Bundesarchivs gegenüber vor allem den Archiven der parteinahen Stiftungen gesetzlich zu begründen, die von sich aus natürlich keine Veranlassung sehen, die fraglichen Unterlagen in ihrem originären Kontext zurückzugeben.
Many things have changed in recent years, including in the courts. I urge all colleagues from the press, research and civil society to enforce their right to information, even juridically. It can only get better.